If you don't plan, you're stupid.
You are listening to If You Don't Plan, You're Stupid with estate planning attorney Andy Rosenberg. Andy helps Florida families avoid costly legal traps and make smart, lasting decisions about their future. My name is Kevin Rosenquist, and today we're tackling a really common mistake people make when trying to keep it simple, putting their child's name on their house deed or bank account. It might sound like a shortcut to avoid probate, but actually, it can lead to some serious unintended consequences. Andy, welcome back.
Hey, thanks, Kevin. Thanks for having me as always.
Why do people think that putting their child's name on a deed or bank account is a good idea, and then tell me why it's a bad idea?
Well, I mean, most people, although, Kevin, I am an estate attorney, so I see people disinherit everybody all the time, including their children. But most people want to have their wealth go to the next generation, their kids and grandkids.
Sure.
So it's a natural thought process, natural consequence to just say, oh, you know what? Let me just put my kids on the bank account so that if something happens, they get access to it and it's not a problem. So, I mean, fortunately or unfortunately, that's what happens. And I see it every day. And I tell people every day, there's pros and cons to this situation. And people are like, holy cow, I can't believe that it could do that. And I'm like, yes, it can. And then they realize it's like a light bulb goes off in their head saying, oh my goodness, what do we do? So that's why you meet with someone like me to talk about this stuff. But yeah, it's done all the time. People do it all the time. It's a natural thing to do, to put your kids on accounts, and they don't realize the consequences, which I guess we want to talk about.
Yeah, now. I would say so.
Okay. So I talk about this. This is one of my favorite slides actually in my workshops. Is I have a slide about, and I ask the question. I ask this question. I go, how many of you have kids? And then they raise hands. And I go, how many of you have kids with their names on the accounts with you? And then the hands still stay up, but some drop. And then I say, well, how many of you believe it's a good thing or a bad thing? And they all drop their hands, and no one's afraid. Everyone's afraid to answer.
Yeah, everyone doesn't. No one wants to be. They're like, oh God, I'm being baited here.
Yeah, exactly. So here's the negatives of adding kids onto a bank account situation. So the first one is what happened. Let's say that I have two kids, which I do, Allie and Jason. And Jason's in law school. And let's just say that I have a bank account with my son, Jason, and I fund it with $10,000 or $15,000. So I have money available when he needs it, and I can make sure he has money to do things at law school. So we do that. And then let's say that Jason is driving a car. He's actually driving a Jeep that I own, by the way, but he's driving a Jeep. And he gets into a fender bender, and he hits somebody. So it's his fault. And he ends up hitting someone, and it ended up being a more serious accident than anyone thought. And all of a sudden, they decided to hire an attorney, and they decided to file lawsuits against Jason. Okay. The issue is they're going to come after Jason. And they're going to come if it's an attorney that knows what they're doing, and if it's a bad enough lawsuit situation, they're probably going to do an asset search to see what assets Jason might have, because maybe the car insurance he had in this situation wasn't enough.
Mm-hmm.
And so they do an asset search, and guess what comes up as part of the assets? The joint bank account that is mine with Jason's name on it. Well, guess what? That joint bank account is now subject to a lawsuit. Even though Jason didn't put any money into it, even though Jason, technically it's not his, he knows it's dad's money for his benefit, but because it's in joint names with right of survivorship, it is Jason's as much as mine legally. And if he were to get sued, the creditors can come after those assets. So that is the number one reason.
Yeah.
Why you should not put kids on your bank accounts, because God forbid they were to get into a lawsuit situation, it was their fault. They could potentially come after those assets that you did. So that's number one. Did that make sense?
It makes perfect sense. And before you get to the next one, I'm curious, why do that why do that instead of just making a plan to leave? Do people do this in lieu of an estate plan? Is that kind of what they do?
Yeah. Well, I mean, people don't know. I mean,
Mm-hmm.
people don't quite understand. First off, if you're not in the field that I do, which is estate planning, it's not common knowledge to you probably on how to handle things. So it just makes common sense. You go to the bank account and they say, "Hey, listen, I got my kid. I need my kid to have the ability to be able to get access to this." And the bank's going to say, "Yeah, well, just open it as joint tenancy with rights of survivorship with your son," and then that's how it starts.
Mm-hmm.
So what happens is people don't understand, and so they don't know that is titling of assets is so key to estate planning. And I mean, it is a huge topic that I deal with in my workshops, is just titling of assets. And it's a good 20 minutes of the entire hour presentation is on titling of assets. And so your question is, why don't people just do other stuff? It's because they don't know what that other stuff might be. We'll get into it. I know with a few of the questions you're going to have in a little bit here, but there are other things to do instead of this,
Okay.
instead of putting one on an account. So
Oh.
that's number one.
So number one, okay, got it.
Creditor claims, right? You get sued, you're coming after it. Number two, let's say my son and I have a joint account, and he's married, and they decide to go for a divorce.
Mm-hmm.
What happens? That money, then that joint account, even though he never put a penny into it, it was all my money, but because it's jointly held, it is now part of that divorce proceeding. So it opens up the Pandora's box for creditor claims and divorce proceedings, if that ever should happen. And the third issue that I always bring up is, what happens if Jason, in this example, is not financially savvy and made some stupid investment decisions or whatever, and has realized he can't get out from underneath things, and he had to file or is going to file for bankruptcy. Now what? Well, guess what's part of the bankruptcy court?
Yep.
That joint account. So the three whammies, in my opinion, of putting a kid on an account: creditor claims, divorce proceedings, potentially if they're married and they might get divorced down the line, and the third one is bankruptcy concerns. Those are the three whammies, in my opinion, of having someone put on as a joint owner.
Wow, those are pretty big whammies.
I think they are. Yeah, for sure. Yes, I agree.
So, okay, so what about tax consequences? Are there tax consequences that can come from adding a child's name to property or assets?
And that is another huge consequence, but I don't bring it up very often because it gets a little confusing.
Okay.
But we're here to talk about, because this is a podcast situation.
It is a podcast situation.
Yes. So the answer to your question is, it screws things up for taxes. And we're going to get into the weeds a little bit, Kevin. So please tell me if it doesn't make any sense.
Okay.
I'm going to use, I won't use real estate right now. We'll just keep it as investment accounts. So let's say that I have an investment account at Fidelity, and I'm just going to use $100,000 just because it's an easy number to use. We have $100,000 and it's my account. I decide to add Jason on as the account holder with me. So now we got all those issues that we just talked about, right? The other issue that we didn't talk about is that I just caused a potential tax issue. And let me explain to you what I mean. Two issues, actually. Number one is, when I pass away, there's something right now. I mean, the laws can change. We never know what the government's going to do. But right now, we have something called a stepped up death benefit tax. So what that means is that all the assets that I own, that I bought, let's say I bought these investments, I put $30,000 in the investments, and today's value, it's $100,000. The account's $100,000. There's a huge amount of growth there, right? There's $70,000 of growth in that example, right? I spent 30, and it's been invested in over the years and it's grown to 100. So that's 70,000 of growth. If I were to sell my assets today, there would be 70,000 of taxes. That's called capital gains tax.
Mhm.
Does that make sense so
Yep.
far?
Yeah.
Okay. So when I pass away, and if in my estate plan I give it to Jason, as the example here, Jason would get it at that at the $100,000 mark, and he could sell the assets the next day for 100,000 and have zero capital gains tax. It gets washed out with death. It's called a stepped up death benefit for capital gains. When we put our kids on an account like we did in this $100,000 account, technically 50% of anything I put on, we lose that stepped up basis on. So in this situation, there's 70,000, $35,000 worth of taxes are lost, or better yet, are going to be claimed when he was to sell something the next day. If I die so I die, and Jason owns it, right? Because it was joint tenancy automatically, and it's 100,000, and then he sells everything for 100,000. There's going to be $35,000 worth of capital gains taxes that are going to have to be owed because we lose 50% of that stepped up death benefit just by adding him onto the account.
Right. That actually makes sense.
So that's the one huge problem. The second problem, it's not as big now, but it used to be, but it is an issue, is that's considered a gift. When we added Jason onto the account, it was never his, right? And it's worth 100,000. Technically, he got gifted $50,000 of the 100. And so you're supposed to file a gift tax return. Most people don't,
right?
But you're supposed to. And then that gets offset against your estate tax due at the end of your lifetime. It used to be a bigger deal, Kevin, when the estate tax was like $600,000 or $700,000 total. And what that means is that when you passed away, if you had $600,000 or less of all of your assets, there was no tax. Anything above that, you would get hit with an estate tax. Well, so if we did $50,000 as that gift tax, we'd have to subtract 50 from the 600. So now if I had more than 550, so that used to be a big deal when the estate tax was 600,000.
Okay.
Now, as of today's recording, that estate tax, at least in Florida, it's 15 million. So it's not a big deal,
right?
For 99.9% of the
most
population.
people don't get there. Yeah.
Right. But the big, huge deal is that loss of the stepped up basis that we talked about, that 50% loss. And let's give a real life example. I got my house, right? My house, my wife and I own. And let's say we added Jason onto the house as a joint owner, which we would never do, which we've talked about why. But we added him on. My wife and I pass away. It's automatically his at that point.
Sure.
The house, my wife and I bought the house for $359,000 many years ago. Today's value is 1.5 to 1.8 million. Let's just use 1.5 million. Okay. So if we bought it for 350 and it grew to 1.5, that's at, what is that? 1,150,000 of growth, right?
Yeah.
That's a huge amount of growth.
Yes.
That capital gains tax is gone. And now at 1.5 million, Jason could sell it and not have any capital gains tax and no tax consequence, right? No estate tax, no capital gains tax. But because we added him onto that real estate while we were alive as a joint owner, technically 50% of that huge growth of that 1,150,000, he will not get the stepped up benefit on. So let's just round it and say that's 600,000. He'll have 600,000. He sells it the next day when we die for 1.5 million. He's going to have a $600,000 capital gains tax.
The amount will be 600,000, or
it will be based on 600,000.
Okay, yeah, that's what I thought. Whoa.
Let's just say it's like 15, 20%.
Yeah.
Let's say 20% of 600,000 what is that? 120,000?
You're asking the wrong guy. I'm a podcast host, not a math guy.
I think it's 120,000 in taxes.
I would trust you, and that's a lot of money.
For us, what everyone's trying to do is something simple and do the right thing,
Right.
and that's a consequence of it.
Wow. Yeah, that's a significant consequence.
It's a huge consequence, yes. We haven't
Okay.
even talked about some of the other problems that you have when you do these things.
Let's go.
All right. Let's talk about the real estate. So now my wife and I own the property, and we added our son on, right, as a joint owner. Now we want to sell the property. I can't sell it without him having to sign because he has control as well. I have lost control of my asset. I can't do anything without him being involved. It's a problem. So we got those issues. In addition, what happens if he becomes disabled or incapacitated? Now what? Now I can't sell my real estate with my wife because he's still part owner as a joint owner with us. We have to have a guardianship appointed for his portion to name someone to have the ability to sell it for us.
Wow.
So yeah, I mean it's a major control problem. Also, here's a huge thing: it's unintentionally disinheriting kids. So in this situation where let's go back to the investment account where we had $100,000 investment account, and I put Jason on there, and then my wife and I were to die, it now goes to Jason automatically because it's joint owner. It goes to the survivor. He got 100,000, and let's say my will or my trust says I want everything equally divided 50-50 between my daughter Allie and my son Jason. Well, Jason got 100,000 more than Allie, and there's nothing she can do about it because he was on that one account.
He's on he's on the account. Yeah.
So it's joint tenancy is a problem.
It makes a lot of sense. It makes a lot of sense. Like I totally understand why people wouldn't realize these problems, but as you're saying them, I'm like, oh yeah, that makes sense. Oh yeah, that makes sense. So it really, once it's told to you, it does seem like a bad idea.
It's not a good idea at all. And then I have people that put kids on accounts and they're under 18.
Oh,
which is a worse idea.
Yeah.
It went from a bad idea to a horrible idea because now if you have a minor on an account and something happens or you want things done, it's a problem because they don't have the legal right to sign off on anything. So, I mean, it's just, or they put grandkids on an account or whatever. It's, just turn the domino and have it fall over many times over is those cascading of problems is what can happen when we do this.
Okay,
I'll give you a quick example.
Yeah,
I know
please.
we're running out of time. Quick example. I did a workshop. I had a client listen to that whole, do we put kids on accounts situation. She came up to me and said, I have to meet with you. I got to meet with you. I said, you can't do it. You got to schedule a meeting later. So she scheduled a meeting. I sat down with her and she said, listen, I have one son. He's a chiropractor. And I have my real estate, my investments, everything is owned jointly with him. And I said, okay, what's going on? And she said, he's not doing well. He's getting ready to file for bankruptcy. And I said, unfortunately, you're in a lot of trouble. I said, you need to meet with a bankruptcy attorney because I don't know what the clawback rules are. So if we were to take his name off of the account and it's just you now, and he were to file bankruptcy a month later, that may not hold up because there might be bankruptcy clawback rules that says any transfers made within the past 2 years, 3 years, 5 years can be clawed back into the bankruptcy.
Right. That was actually going to be my final question is, can you go back?
Yes, you can go if you had to file bankruptcy or something like that.
No, I mean, just in general, so you can just take people off and you should be fine.
Absolutely.
But if there's a problem.
In fact, that's what I recommend doing. Absolutely.
Yeah, okay.
And the better way, we didn't talk about what the better way is. I know we're running short on time. The better way to do that is instead of having it as a joint owner, the investment account with my son, have it in my name alone, keep it in my name alone, and add a beneficiary to the account. So a TOD or a POD, transfer on death or payable on death, which is a beneficiary form, and put your kid on there. And then they have no legal rights while they're alive. But when you pass away, it will automatically go to them without probate.
Okay.
Yeah.
Okay.
So that's one option. A lot of times that doesn't make sense because maybe the kid's not good with investments and this or that, or you don't want the kid to get the money outright. So then we got to talk about trust work and everything else. But the worst case scenario is putting a kid on an account with a joint ownership. I'd rather see better do a TOD or a POD. Best case scenario is, if it makes sense, do trust work.
Okay. Wow. Well, I hope that gave some people some good information. I know a lot of it I didn't know about. So I definitely appreciate you going over all that, Andy. Shortcuts can turn into disasters when it comes to estate planning. So if you've added someone to your deed or account, or if you're thinking about it, visit rosenberglawfirm.net, get real advice before it costs you. Also, don't forget to subscribe, leave us a review. We very much appreciate it. Andy, always love chatting with you. Thanks so much.
Thanks, Kevin. It's always enjoyable, and the time does fly. I will
It sure
tell you
does.
that.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.